To order. Welcome to meeting number 8 of the House of Commons Standing Committee on Justice and Human Rights. Today, we're obviously in a hybrid format. The proceedings will be made available via the House of Commons website. Just so you're aware, the person that is speaking is the one that will be shown on the webcast rather than the entirety of the committee. To ensure an orderly meeting, I'd like to outline a few rules to follow. Members and witnesses, you can speak in your official language. Interpretation services are available for the meeting. You have the choice at the bottom of your screen to either floor, English, or French. So please select the language that you need in your headset. For members that are participating in person, which is myself and Mr. Cooper, we are definitely following our health protocols here with our masks. So for members, before speaking, please wait until I recognize you by name. For those participating virtually, please click on the microphone icon to unmute yourself before speaking. And then do mute yourself once you're not speaking. Those that are in the room, we're following the normal proceedings for our microphones. A reminder that all comments by members and witnesses should be addressed through the chair. When speaking, please speak slowly and clearly. Allow time for interpretation. When you're not speaking, your microphone should be on mute. With regards to the speakers list, Mr. Clerk and I will do our best to maintain a consolidated order of speaking for all members, whether you're participating virtually or in person. When you're participating virtually, I would appreciate if you can use the raise hand function on your Zoom so that I can see who has their hands raised. The person who raises their hand first basically gets to go first. And I'll make sure that Mr. Cooper is kept on that list as well as he's appearing in person. So before we move on to the clause-by-clause consideration of Bill C-7, I'd like to get the committee's consent for the small budget of $4,125 that has been prepared in relation to the study of this bill. You all got a copy yesterday. It was sent by Mr. Clerk. The budget will pay for the phone lines necessary for the holding of hybrid meetings, meals, and beverages, and the headsets sent to witnesses. So if I ask members for your agreement in passing this budget, you can show me a thumbs up if that's good. I see everybody's thumbs up. Perfect. Thank you very much for that. Do I need to sign this, Mr. Clerk?
Madame la Présidente.
Later.
Madam Chair, Madam Chair, Madam Chair, before studying or talking about clause by clause, I might be overly optimistic, but if the meeting would finish before 1 o'clock, I just wanted to say that I would need a 5-minute pause so that Mr. Fortin could replace me if the meeting ends earlier, and then I would leave. Would that be okay? Don't cry.
First, Monsieur Terrio, if the meeting ends earlier than 1, which I quite honestly doubt it will, you're most welcome to be replaced by Monsieur Fortin. Thank you for flagging that for me in advance. I appreciate that. So I'd like to welcome our witnesses today, namely our government officials who will assist us in the clause by clause for our technical questions. From the Department of Justice, we have Joanne Kleinberg, who is the acting general counsel. We have from the Department of Justice, Caroline Quesnel, counsel for criminal law policy section. From the Department of Health, we have Abby Hoffman, a senior executive advisor to the Deputy Minister. From the Department of Health, we have Sharon Harper, who is the Director General, Strategic Policy Branch. And also from the Department of Health, we have Karen Kush, Senior Policy Advisor, Strategic Policy Branch. And just a note to members, these witnesses are here to answer any technical questions that you have with respect to any of the amendments that we're discussing today. So right before we go into clause by clause consideration, I know Mr. Manley had mentioned this, but we did receive 2 amendments that I just want to make sure that you have in your amendments package this morning. Which was an amendment by Mr. Manley that replaces PV4, which is page number 18 in your package, and an amendment from Mr. Theriault that replaces BQ4, which is at page 21 in your package. Does anybody have any questions around those 2 changes at this time?
Sorry, Madam Chair, when were these circulated?
It would have been this morning, and it would have been circulated by Mr. Clerk.
Okay, thank you.
Can you? So on that, Mr. Maloney, we're just going to try to resend them so that everybody has them. If anybody does not have them, just let us know so that we can direct you. Madam Findlay, I see that your hand is raised.
On that same point, I just would like to have them recirculated and to make sure I have the latest.
Absolutely. So Mr. Clerk is just doing that right now. Et voila. Has everybody received them now? So just to again clarify, PV4 replaces page 18 in your package, and BQ4 replaces page 21 in your package. Now, if everybody has made those replacements, just give me a thumbs up so we can continue with clause 1.
I haven't received them yet.
Okay,
Yeah,
we'll give it a
neither
few minutes. We'll give it a few minutes.
Oh, I think it's still in my outbox.
MOG's not on top of the ball today. What's going on?
Network issue, Madam Chair.
It was sent at 9:11 a.m. this morning. So if you'd like to look in your inboxes, Mr. Moore, you have your hand raised as well.
Yeah, just a procedural point on the amendments. We had a deadline to submit them, and then we kind of got a flurry of amendments last night. What's the what's the process on that? It's happy to see amendments, but we had the Conservatives, we had tried to get ours in by a deadline that you had proposed. I know someone could move an amendment from the floor, so it's helpful to have it in advance, but what's the mechanics on that, Madam Chair?
Yes, Mr. Moore, can you hear me?
Oui.
Oh, thank you. This is the legislative clerk here, Philippe Mela. Yes, you're right. There is a deadline that was set, and thank you for sending your amendments on time. That allows us to look at them procedurally, but also to prepare the package of amendments and to prepare the agenda. So everybody has the same documents to follow the meeting properly, and it's organized, and it's easier to do it that way than having amendments coming from the floor. Now, on your question relating to the amendments that we received last night, generally speaking, we prefer to circulate them ahead of time so members can have a look at them. And also for us, it's easier to put them in the package again ahead of time rather than having them moved from the floor. So that's the reason why they were circulated this morning.
And thanks for
that. So would we get extra credit for having put ours in on time, or how does that work?
Thank you for that, Mr. Moore. Absolutely, there's lots of extra credit to be given to you and in fact the whole team, to everybody who got their amendments in time. It's just doing it virtually. It's logistically a lot easier when members have the amendments in front of them, as so that all the language is conveyed properly as we're doing the virtual moving from the floor. It just makes it a lot easier for us to have them before us.
Madam Chair,
Yes, Mr. Maloney.
I believe I just received the new email, but it's the body of the email, but I don't think it has the actual attachments, if I'm not mistaken.
I will send it with the attachment.
It is being resent with the attachments.
Okay, thank you.
And I found it from 6:11 this morning for me.
6:11.
So,
Wow.
thank you.
Right. Your time zones are different.
right.
Out of the outbox.
Out of the outbox and
Thank you.
into the fire. If members can just confirm for me that they've received the new email with the attachments. Mr. Varani, I see a thumbs up. Mr. Manley, Mr. Calloway, Mr. Lewis, Mr. Songa, Mr. Garrison. Okay. And Mr. Maloney, Madam Findlay, have you received them? You have. Perfect. Okay. So that's great. So just again, just to confirm, the PV4 replaces page 18. BQ4 replaces page 21 in the package that you would have received. So on this, pursuant to Standing Order 71, Sub 1, consideration of the preamble will be postponed until the very end. So at this time, I call Clause 1. In Clause 1, we have a number of amendments, and I will just go over them. The first one would be NDP 1. And I do have to rule on this. The amendment seeks to amend. Oh, sorry, give me a second. Sorry. I forgot to allow Mr. Garrison to move it first. Mr. Garrison, would you like to move NDP 1?
Thank you very much, Madam Chair. I guess so you've suggested we're just moving the amendment at this point, so I will move for consideration of the committee NDP 1, which deals with the question raised by the Canadian Nurses Association.
You can speak to it more than that, Mr. Garrison, if you'd like.
Oh, okay. Thank you very much. The only substantive change here is to add words to an existing clause, which are at the end of this clause. So the drafters felt it needed to be there, I guess, in the fullness of the clause, and that is whether or not the person requires the information. Nurses Association talked with us and included in their brief discussions of how nurses and other professionals, including social workers, psychiatrists, often have intimate conversations with patients about their options, about the challenges they're facing. And what they wanted was to make sure that none of the nurses, psychiatrists, social workers, or other professionals would be at risk for prosecution under this law for discussing as an option medical assistance in dying, whether or not the person specifically requested that discussion or was simply talking about the kinds of challenges they were facing and the options that were in front of them.
Thank you, Mr. Garrison. Madam Findlay, is that your hand raised on this?
Nope.
No. Okay.
No.
Thank you.
Sure. Taking it down. Sorry.
Okay. Thank you. So I do have to rule on this. This amendment seeks to amend Section 241 of the Criminal Code related to suicide. As the House of Commons Procedure and Practice 3rd edition states on pages 771, an amendment is inadmissible if it proposes to amend a statute that is not before the committee or a section of the Parent Act unless the latter is specifically amended by a clause of the bill. Since Section 241 of the Criminal Code is not being amended by Bill C-7, it is therefore my opinion that this amendment is inadmissible at this time. We will now go on to Bloc Québécois 1. Monsieur Theriault, if you'd like to speak, move this. And
Madam
speak
Chair, I do have my hand up.
Oh, sorry, I didn't see that. Go ahead, Mr. Garrison.
So I think the intention of that rule of the House is to make sure that we are dealing with issues that are dealt with in this bill. Clearly, this deals with issues that are before the committee. Clearly, this deals with issues of concern in Bill C7. So I'd like to challenge the chair in the ruling that this is beyond the scope of the bill.
Thank you, Mr. Garrison. So in this instance, my question then is, shall the ruling of the chair be sustained? And it comes to a vote.
Thank you, Madam Chair. Mr. Cooper?
I oppose the ruling.
So therefore, you're voting against
Voting
the
against.
motion.
Yes.
Ms. Finley? Ms. Finley?
I oppose the ruling.
Monsieur Theriault?
Je suis pour l'amendement.
I'm for the amendment and against the chair's decision. So you're voting. I didn't hear you. You're voting against. Then that's correct.
I'm voting against.
Mr. Calloway?
For?
Mr. Lewis?
I vote against the motion.
Mr. Maloney?
I vote for the motion.
Mr. Moore?
I vote against the ruling of the chair.
Mr. Sangha?
Okay, I vote for the motion.
Mr. Virani?
I vote for.
Mr. Zuberi?
I vote for.
So yeas pour 5, and nays contre 6.
Okay. In that case, then we will go to debate on NDP 1.
Madam Chair, point
yes.
of order.
Go ahead, Mr. Maloney.
I expect that this isn't the last procedural discussion or point that we're going to be dealing with today or during the course of these amendments. So I'm not in the room, although I understand that there is one of the legislative clerks is there with you. Perhaps he or she could provide some clarification on this issue, just so that we don't have to do this twice.
Thanks, Mr. Maloney.
Thanks.
Go ahead, Mr. Clerk.
I'm not sure what the question is exactly, Mr. Maloney.
Well, I'm assuming that there was some background to the ruling initially.
Oh, right.
So, but since we voted on it, perhaps my question is more properly phrased in a way. Is our vote overturning the ruling appropriate, given your interpretation of the admissibility or inadmissibility of the proposed amendment?
Yes, I provided the advice to the chair that the amendment be ruled inadmissible. After that, it's up to the chair to decide if it is really inadmissible or not, and then the ruling is issued. And after that, once the ruling is issued, the proper course of action, if any, would be to appeal the decision of the chair, as Mr. Garrison did, and then proceed to a vote. If the decision is sustained, then the amendment remains inadmissible. If it's overruled, we proceed to a debate and a vote eventually on the matter.
Thank you very much. Does that clarify for you, Mr. Maloney?
I suppose, but if in your opinion, the original proposal was inadmissible, I understand we voted on it. Is there a further step to be taken now to clarify your opinion? Like, what's the remedy from here?
So, given that I made a ruling and it was challenged and then voted on, and my ruling was ultimately denied by the committee members. So now what we're doing is debating NDP 1 on its merits. And I encourage members to rely on the department officials to also seek clarification as to what NDP 1 does. I see Mr. Varani is next on the speakers list. Go ahead, Mr. Varani.
So thank you for that, Madam Chair. It's my understanding, so when you go back in the medical assistance and dying sort of regime back to when we enacted Bill C-14, there was a section of the criminal code that was added, right? So we added 241 sub 5.1 to section 241, and that sets out the offenses of counseling and aiding a person to die by suicide. And we did that under C-14 in 2016. And what that section does is clarify that it's not an offense for various healthcare practitioners, including some who cannot provide MAID, like social workers, to provide information to a person about the lawful provision of MAID. And what this amendment does is seeks to specify that no offense is committed when such information is provided to a person who didn't ask for that information in the first instance. And what I understood is that because Bill C7 doesn't propose to amend Section 241 of the code, as such, it is likely outside the scope of the bill. So that is, I think, what you were driving at with your ruling. But given that that ruling has been overturned by the members of the committee, I'm happy to debate the substance of it. So I'm going to make some submissions, but then I'll also invite the department lawyers from the Department of Justice, and welcome to the Department of Justice officials and the Department of Health officials, but if they might want to opine on it as well. But the first point is simply that we all understand the important work that all of the practitioners are doing, be they nurses or be they physicians. So that should be stated on the record, and appreciated the submissions of the Canadian Nurses Association in that regard. Medical regulators or colleges are the ones that are turned to choose to reconcile the competing interests from a medical practice point of view. So that's the first point. But here we're dealing with the criminal law, and that's what C7 is all about. And in my from my perspective, there's actually no problem here to address. There's currently no problem to address, because when you trigger the criminal law, it's not actually the providing of information, but the intention of the person doing the providing that is at issue. So merely providing information about MAID one way or the other doesn't amount to counseling or abetting somebody to die by suicide. Counseling or abetting somebody to die by suicide requires an intention to encourage or persuade someone to die by suicide or MAID, whether or not they actually carry it out, which is important. So whether or not a patient requested information about MAID is not directly relevant actually to the guilt or innocence of somebody who provides that information. The intention of the person who provides the information is the critical factor. So on that basis, I don't think that this is addressing an issue that arises properly under the scope of the criminal law as it's currently constituted, because this is about the action as opposed to the intent of the individual. And the intention of the individual is also critical to the evaluation of the crime if a crime is deemed to have been committed. And that crime could be committed independent of whether the person actually passes or not. So those would be my sort of perspectives. I'm wondering if Ms. Kleinberg or Ms. Quisnell might want to weigh in on this from a departmental perspective.
Thank you, Mr. Varani. Go ahead to the department if you can please comment on this.
Yes, thank you very much, Madam Chair. I could say that from a Department of Justice point of view, we would agree with the analysis just provided by Mr. Varani. And just to add a few small nuances to that, I think that we would say that it may, in fact, give a false impression to some practitioners that they are able, in any circumstances, regardless of what their intention is, share that information. So that there is one danger in making an amendment that is not legally necessary and doesn't actually change the scope of the offense because of the requirement for an intent to persuade or encourage. And then the other concern would be that if the medical regulators do in fact take up this issue and set down some clear rules, there would be the potential for those rules to come into conflict with what is in the criminal code. So that might be another consideration to take into account. Thank you.
Thanks very much for that. I do have Mr. Moore next on the speaking list. Go ahead, Mr. Moore.
Well, thank you, Madam Chair. And I guess I had raised my hand back when the question was raised about how we proceed in matters where they're ruled out of order. I think that's been dealt with, but I would say, as always, that's on a case-by-case basis and a ruling-by-ruling basis. Speaking now to the actual amendment that's been moved, through you, maybe I could ask Mr. Garrison his thoughts on it, but I was quite profoundly impacted by the testimony of Mr. Foley, who appeared at our committee. And I don't know if all members have had the opportunity to listen to the recordings that he made as doctors were basically, I mean, it sounded to me encouraging him to consider MAID in the context of what it was going to cost him to stay in the hospital. They said in the recording, look, the per diem rate for you to stay at this hospital is $1,500 per day. So I'm looking at recognizing that the committee has decided to consider this this particular amendment. I just cannot contemplate a situation where we would want to say whether or not the person requests the information. I think someone would be in a troublesome area there. I don't think we want to send a message that even where a person expressly does not want to consider MAID, healthcare providers are going to be in a position where they keep bringing it up, and that's what appears to have happened with Mr. Foley in this recording. And I don't know if Mr. Garrison heard the same testimony I did, but this amendment, unless there's a further explanation he could provide, runs completely counter to the very moving testimony of Mr. Foley, who did a great job presenting at our committee. So maybe we get some further clarification on that. But my inclination would not be to support this particular amendment.
Thank you, Mr. Moore. And luckily, Mr. Garrison is next on the speaking list. So go ahead, Mr. Garrison.
Thank you very much, Madam Chair. I just need to add one preface here, as you did not give me a chance to state the reasons for my challenge to the chair. And I would just point out that subsection 241 of the Criminal Code is in fact amended several times by C7. And so that was my basis for suggesting that additional amendments to 241 should be in order. On the question of whether or not this is necessary, a necessary amendment, I know the narrow legal arguments that nurses are, or other health professionals or social workers are covered under the strict letter of the law. But it is also very true that we've had many accusations made about specific cases about the role of healthcare professionals in discussing medical assistance in dying with patients. And I guess in response to Mr. Moore, I would say that I'm very cautious about judging the evidence presented to us before the committee dealing with specific cases when we only hear one of the parties to that case. And if in fact there are serious allegations, as have been made several times before the committee, of inappropriate actions by healthcare professionals, those should have been raised with medical professional bodies or in extreme cases with the police, and dealt with where people had a chance to present both sides of the story and have it considered by an impartial body. So again, I believe that there is a risk of constraining the conversations that healthcare professionals, including nurses and psychiatrists, can have with their patients in the way that the bill is worded now, and that this is simply a further clarification of the ability of professionals to discuss fully the options with their patients. Thank you.
Thanks for that, Mr. Garrison. I'm just going to quickly turn to our legislative clerk to clarify on what portion of C7 is being amended in the criminal code. Philippe?
Yes, thank you, Madam Chair. The bill amends section 241.2, which is a different section of the Criminal Code than 241 and 242 and 243. 241.2 and again, 241.31. And that's it. So those are different sections of the Criminal Code than 241, period.
Thank you very much for that. I do have Mr. Kellaway next on the speaking list. Go ahead, Mr. Kellaway.
Thanks, Madam Chair, and hello, colleagues and officials. Just wondering, from a department point of view, are there other elements beyond what we've heard through Mr. Virani's question and answer that makes this inadmissible? I'm just curious to kind of do a deeper dive on, are there elements that haven't been brought up so far that would bring to light the nature of it being or the opinion being inadmissible? Thank you.
If the department wants to answer that question.
Thank you, Madam Chair. I don't think the department would have anything to offer on the question of the inadmissibility of the motion.
Thank you.
Thank you, Mr. Kellaway. I have Madame Findlay next on the speaking list. Go ahead, Madame Findlay.
Thank you. I have a question and then a comment. With respect to the question, just on the discussion we just had around admissibility, I just want some clarification there because it relates not just to the present amendment, but could relate to others now and in the future. I would have thought that when we are dealing with a section of the criminal code, it would be the whole section. Are you telling us that unless an amendment relates to the specific subsection of a section, that we cannot entertain it? That is somewhat of a surprise to me.
Yes, you would be right by saying that when a section is open, you can deal with any part of the section. Unfortunately, section 241 is not opened by the bill. There are other sections. 31.2 is a different section of the Criminal Code. It's not a subsection of 241. And if you look at the title of in the Criminal Code, section 241, the heading is called suicide. And if you go the next section of the Criminal Code, which would be 241.1, the heading for that one would be the medical assistance in dying. So there are two different sections. And 241 is not being dealt with by Bill C7.
Right.
Thank you. I hope that answers your question, Madame Findlay.
Yes, it does. Then I have a comment. My concern is along the same lines as Mr. Moore's, Madam Chair, that we also heard evidence testimony from Taylor, and she's a young woman in her 20s. She ended up being diagnosed as having pneumonia, as I recall, and the normal course of treatment for that would be oxygen, and yet the practitioner was discussing MAID with her rather than giving her the oxygen she needed for her pneumonia. And as she said, you know, a normal, in any other normal circumstances, a young woman presenting herself to emergency in her 20s would not have to go through all that before she was given oxygen for something like pneumonia. Mr. Foley's testimony, of course, was very compelling, but in some ways, I was more shocked by what Taylor had to say, because she was someone who certainly did not want to enter into this discussion at all. She wanted treatment for her current situation and eventually got it. But I'm very concerned about there being no onus on any practitioner in the sense that they should not, I don't think they should bring it up. It should be patient initiated. If it's patient initiated, then there are rules around the form of conversation, the nature of that engagement. But when someone is coming into the care of caregivers in the health system for something totally unrelated, and yet is being judged by that practitioner as someone who maybe should just end their life, I find that very difficult. So this is not an amendment I could support for that reason. Thank you.
Thank you, Madam Finley. I have Mr. Moore next on the list. Go ahead, Mr. Moore.
Thank you, Madam Chair. I guess some of the commentary has been not on the amendment itself, but on the process we go through if an amendment is ruled out of order. And just some clarity on that, maybe from Legislative Council, but ultimately this committee decides what amendments go through, irrespective of that ruling, if the ruling is overturned. Because I don't know if it's an attempt to maybe revisit it or re-argue it, but ultimately if the committee says, in spite of the chair's ruling, we would like to deal with this amendment, then it's within the committee's power to do so. Is that a correct understanding?
You're absolutely right, Mr. Moore, but I will pass it on to Mr. Clerk to give more information.
Thank you, Madam Chair. Yes, you would be right, Mr. Moore. It's always the prerogative of the committee to decide what the committee wants to achieve and do, regardless of the rules. However, any amendments that is ruled inadmissible in committee would end up in the report that would be presented in the House for the reprint of the bill. If a member would raise on the point of order in the House at that point before the start of report stage, the Speaker would probably come to us and ask the same question regarding the amendment. Is the amendment inadmissible or admissible? Of course, we would have the same analysis that we provided to the chair of the committee, to the Speaker of the House, and what could happen without presuming of what could happen in this case, but what could happen and what has happened in the past. The Speaker of the House could simply rule that the amendment was indeed inadmissible and still is at report stage, and remove it from the report from the committee, order a new reprint of the bill, and the amendment would therefore be eliminated from the bill. So that's the second step past committee stage.
Does that answer your question, Mr. Moore?
That's great, thanks.
Thank you. I have Mr. Maloney next on the speaking list. Go ahead, Mr. Maloney.
Thank you, Madam Chair. Mr. Moore was addressing the same point I was going to raise. The only thing I might add is that in anticipation of this maybe happening again during the course of our discussions here, it might be helpful to have the clerk, or the legislative clerk, provide us with the information and the analysis he provided you in assisting you making your ruling before we vote to overturn it. I'm not suggesting that anybody's vote would have been different, or the outcome of the vote would have been different on this particular case, but I just think it's best that we're all fully informed, or as fully informed as possible, before we're voting to overturn a ruling from the chair.
Thank you very much for that, Mr. Maloney. I'll make sure that in any future rulings that we'll definitely do just that. Mr. Lewis, I have you next on the list. Go ahead.
Thank you, Madam Chair, and good morning, colleagues, members of the committee. Just a couple of comments, then a question to the legislative clerks. Mr. Garrison, specific to you, sir, with regard to this this amendment, I know that during your I think it was your second set of remarks, you had mentioned the risk of constraining conversations, which I find a little bit mind-boggling, only because I do believe that you voted, sir, against additional meetings, specifically on the motion I put forward to hopefully allow for more folks with disabilities, including the Indigenous. So very interesting comments on that front. Specifically to my question, Madam Chair, through you to legislative clerks, I believe I understood the answer with regard to the speaker getting the quote unquote final say, but I'm wondering if it would also further not go to the members of the House to rule on that. And if I could please get some clarification, I'd appreciate it. Thank you, Madam Chair.
Thanks, Mr. Lewis. And I'll just remind you to not address members directly, just to keep the decorum of the committee to refer to me instead of.
My apologies to the member, the NDP member.
Thank you. I appreciate that, Mr. Lewis. If I could just refer to our legislative clerk then.
Again, to restate what I stated just a minute ago, if the amendment were to be adopted today, this amendment would be placed in the report that will be tabled in the House at a later day. And at that point, somebody, a member of Parliament, could raise a point of order to the Speaker of the House to say, Mr. Speaker, I believe there are some amendments that were ruled inadmissible in committee that are presently in the report. At that point, the Speaker would turn to us for analysis of the said amendment, analysis that would be the same as the one we provided to the chair of the committee. And at that point, it would be up to the Speaker to decide if indeed, basically, he agrees with us or not. And if he does, usually the course of action is to take the amendment from the report, remove it from the amendment from the report, and then ask for a reprint of the bill without the amendment in it.
Thank you. Thank you for that. We'll go on to Mr. Garrison. You're next on my list. Mr. Garrison, go ahead.
Thank you very much, Madam Chair. And in response to the question from Mr. Lewis, he knows full well that I have argued very strongly that all of these issues need to be aired before a special committee of the House in the statutory review, and in no way have I suggested that these issues should not be discussed further. And that, of course, is quite a different issue, the one I was referring to, and perhaps in my remarks I should have included not to constrain lawful conversations. And in the advice that we heard from department officials, what they have said is this amendment does not change the law in this case. It simply clarifies that having lawful conversations between medical professionals and patients is allowed, whether or not they have initially raised the question of medical assistance in dying. Again, the chill that we're placing here on the relationship between patients and those who provide their care is what I'm trying to address, and trying to make sure that that relationship is not damaged inadvertently by misunderstandings of what is a lawful conversation. Thank you.
Thanks very much for that, Mr. Garrison. Having exhausted the speakers list, I'll call the question on NDP 1. Is there any will for a recorded vote or on division?
Recorded.
Recorded. Thank you, Mr. Cooper. So go ahead, Mr. Clerk.
Thank you, Madam Chair. Mr. Cooper.
Opposed.
Ms. Finley.
I'm opposed to this amendment.
Monsieur Thériault.
Je suis pour.
Mr. Garrison.
In favor.
Mr. Kellaway.
No.
Mr. Lewis.
I oppose.
Mr. Maloney.
No.
Mr. Moore.
Opposed.
Mr. Sanga.
Oppose.
Monsieur Virani.
Opposed.
Mr. Zuberi.
Oppose.
So, yeas pour 2, et nays contre 9, 9.
Thank you very much for that, Mr. Clerk. So this so NDP 1 is defeated. We'll now move on to BQ1. Mr. Thériault, if you want to speak to that, please, or move it.
Oui, Madame.
Thank you, Madam Chair. A person who requests medical assistance in dying until the moment that medical assistance in dying is provided is entitled to the same palliative care that they would be entitled to had they not made the request. I tried to ensure that what we've seen during all of the debates, and this was at the heart of the debates when we were studying this bill, I really wanted to bring this amendment forward. When a patient requests medical assistance in dying, this patient must receive palliative care. And some witnesses told us that regarding palliative care, sometimes someone changes their mind because they're being well treated, they're obtaining good palliative care, and this could be at home, in a hospital, or elsewhere. And I think it would be very unfortunate that because there are few resources, it would be unfortunate then to exclude a patient or someone who requested medical assistance in dying, and that this person would not be entitled to the same palliative care that they would have been entitled to had they not made the request. So this is why I'm bringing forward this amendment. Because witnesses told us that sometimes people receiving palliative care do not come back and change their decision, because this is something that we've heard. I thought that it was very important to understand that a choice must be offered, and if you want to have a choice, you can't exclude other choices. And this is why I thought it was really important to suggest this amendment. Of course, provinces and territories manage this, but I still think it is important to ensure that a person who requests medical assistance in dying, when their death is foreseeable or sometimes not, I think it is very important from the onset to really talk about a continuum of services and care that would be given to the patient, because there's a lot of polarization about this, and we've seen this when we heard our witnesses, and this is the intention of my amendment. I did understand the explanations that were given a bit earlier today, but there was a debate about Mr. Garrison's amendment. It was interesting to have a lot of clarity and had we not challenged the chair, we would not have been aware of all of this. So I do hope that I was very clear about the intention of my amendment.
Thank you, Monsieur Thériault. And so I do have a ruling on this. So Bill C-7 amends the criminal code to render medical assistance in dying more accessible to patients requiring it, but does not address the level or the quality of palliative care as is contemplated in this amendment. This is a new concept not envisioned by the bill. As the House of Commons Procedure and Practice 3rd edition states on page 770, an amendment to a bill that was referred to the committee after second reading is out of order if it is beyond the scope and principle of the bill. So therefore, as stated, I rule that this amendment is inadmissible, and I will refer to the legislative clerk to explain a little bit further for members' clarity.
Oui, effectivement.
Yes, please. I would like a bit more information regarding this. What bothers me is that you're talking about the quality of palliative care, and we're not talking about the quality of palliative care. And
thank you. I was just referring to our legislative clerk to give clarity on this ruling. Thank you.
Merci, Madame Chair. Merci, Monsieur Thériault.
Thank you, Madam Chair. I can't hear you. Could you please speak louder? Says Monsieur Thériault. Can you hear me now? No. Hello? Can you hear me? Yes, I can hear you. Sorry about that. Bill C7 does not talk about palliative care. Basically, this bill is about medical assistance in dying. So if you add a concept and if you talk about the quality or the accessibility of palliative care, and if you're talking about having the same level of palliative care, that goes beyond the scope of the bill. And this is what the chair stated as well.
Thank you. I do see a number of hands raised. Is this specific to my ruling or to this amendment? Mr. Garrison, you're at the top of my list. I'll just test the waters with you. Nope. Okay, Mr. Virani? Nope. Oh.
Madam Chair, it's sort of substantively about the amendment and the fact that we're dealing again with the criminal law here. So it's not germane to your ruling, but it's germane to the amendment. I think it's not the purview of this legislation, nor probably is it the purview of the federal government to wade into the type of care, the quality of care, or access to certain types of health care at the provincial level. So to my view, that sort of subverts the division of powers. So I think it should be defeated in any event, but I'm not going to opine on your ruling about admissibility. Thank you, Ms. Seat.
Thank you, Mr. Virani. Mr. Moore, is that for the same?
Yes, it's on the amendment, Madam Chair. You know, my concern with this is, in fact, this has everything to do with palliative care. That is certainly the testimony that we heard on this bill at committee, that the quality of palliative care can have a direct impact on a person's approach to assisted dying. So witnesses told us about a number of factors that go into that decision, and palliative care was certainly front and center as a significant factor. And in fact, when we talk about a person's choice to pursue assisted dying or not, it was presented to us that it's not a true choice if a person does not have access to palliative care. So I disagree. I think this particular provisions amends the criminal code. That was what was required when we brought in C14 and indeed C7. It was required that the criminal code, some provisions be amended when it comes to counseling someone, and the legislation touches on any number of factors dealing with consultation, dealing with the expertise of individual physicians. So I think it's quite clear to me that this particular amendment would be one that should be ruled in order.
Madame Findlay, I have you next on the list. You're on mute, Madame.
Zoom life, sorry. I'm a little confused, to be honest. So I'm just trying to understand this. This amendment speaks to palliative care. We heard a lot of testimony on that. And in the section that is sought, the amendment is sought for, it does speak to being eligible for health services funded by any government in Canada. So, you know, the law as it is already speaks to the type of health care available, and this is just being a little more specific. And I realize that I am a new member of this committee since prorogation, but when we considered as a committee Bill C3, concepts were added on systemic racism based on committee testimony, some of which I had not heard as a present member of the committee. People kept referring to testimony in last February, and it certainly wasn't in the original text, and you didn't rule that inadmissible. So I'm really confused here. This seems to me to be an amendment within the scope of health services funded by a government in Canada. And we went way further, in my opinion, when we not only entertained but adopted changes in Bill C3. I wonder if the clerk or you yourself as well could comment on that.
Thank you for that, Madam Findlay. And our legislative clerk did go into some detail explaining. I can refer back to the legislative clerk, but if you all have the option of challenging my ruling, if that is the case, you're welcome to do so. But I will refer to the legislative clerk to provide further clarification.
I understand that, but I didn't want to challenge the chair until I heard from the clerk again on my point about health services funded by a government in Canada.
Thank you. Go ahead, Philippe.
Yes, thank you, Madam Chair, Madam Findlay. Thank you. You're referring to section of the Act that are speaking about palliative care. But what you have to look at also is the bill. What is the scope of the bill? The scope of the bill was adopted at second reading by the House. And if you look at the bill in itself, rather than the Act, you would see that the level of palliative care that a patient would have access to is not dealt within the bill. So that's the problem here. It's not the palliative care in itself, which is indeed dealt, as you pointed out, in the criminal code. It's the fact that it's not dealt with, even though witnesses came and talked about it. It's not addressed in the bill as far as the level or the same type of palliative care that you would obtain. So that's what makes it inadmissible.
Well, thank you for that. I would challenge the chair's ruling on this. When I think back on the testimony, which we didn't have enough of, frankly, but when I look back on it, palliative care was in the center of much of the testimony we heard. And I know with respect to Bill C3, the social context was given as the reason to include a much broader range of discussion. So I would challenge the chair in this ruling.
Thank you, Madam Findlay. So I will call the question then. Should the chair's ruling be sustained? Go ahead, Mr. Clerk.
Thank you, Madam Chair. Mr. Cooper?
It should not be sustained. I vote against the ruling.
Ms. Findlay?
I vote against the ruling.
Monsieur Thériault?
Je vote pour.
Mr. Garrison?
I vote to sustain the chair.
Mr. Kellaway?
I vote yes.
You vote yes. Mr. Lewis?
I vote against.
Mr. Maloney?
I vote yes.
Mr. Moore?
I vote no.
Mr. Sanga?
I vote yes.
Mr. Virani?
I vote yes.
And Mr. Zuberi?
I vote yes.
So, yeas pour 7, 7, et nays contre 4, 4. Yes.
Thank you. So my ruling is sustained, and again, I had ruled that this amendment was inadmissible, so it remains as such. I do see a number of hands raised. Is this nope? Okay. All right. Thank you, Mr. Moore. Did you want to? So I am coming to you next for moving CPC 1. Is that what you're raising your hand about?
No, it's not, Madam Chair.
Okay, go ahead, Mr. Moore.
Yeah, I'm just on this. Obviously, we've heard a great deal of discussion around palliative care, and I respect the reasons you came to your ruling. But To be very clear, Clause 7 of this bill mentions palliative care. It says that ensure a person has been informed of the means available to relieve their suffering, including where appropriate, counseling services, mental health and disability support services, community services, and palliative care, and has been offered consultations with relevant professionals to provide those services or care. So how can we on one hand say the bill does not deal with palliative care when
Mr.
palliative care is listed in the bill?
Mr. Moore, my understanding, as we've had quite a healthy discussion on this, and I have ruled, the ruling was sustained, and I would like to carry on if that's okay. So, Mr. Moore, I'll come to you to move CPC 1 at this time.
Well, actually, I think it's important that we have clarity on these things. People have taken time to make amendments, and some of the rationale that's being used to exclude them runs completely counter to what's in the bill. So I do think it's important that we have some clarity on that. It impacts how we move forward.
We have answered all questions by all members. At this time, I have ruled, we voted on the ruling, and we need to go forward. Maybe we'll answer further questions when we get to CPC 1. So I'll ask again, Mr. Moore, if you'd like to move CPC 1 at this time.
Yes, I would like to move CPC 1.
Go ahead, sir.
Well, CPC 1 is being moved because of some of the significant testimony that we heard from healthcare providers. I reference a letter that was sent to committee members that was signed by, I think, upwards to 900 healthcare providers, many of whom are concerned about the relationship between patient and their doctor, which is the ultimate trust relationship. There's no more important relationship, certainly, that's not a family relationship than the relationship between a patient and their doctor. And many doctors, with this significant expansion to the assisted dying regime, have raised with us their concerns about the provision of assisted dying and as it relates to them and their profession. And these are hardworking individuals that help make our community and our society better. They help to heal people. That's what they do. It's what they want to do. But they're concerned about the impact of this legislation on their ability to do that, and principally on the relationship they have with their patients. So this amendment, CPC 1, would provide for conscience protections for physicians as it relates to this expanded assisted dying regime. Thank you.
Thank you, Mr. Moore. And at this time, I would like to give a ruling on CPC 1. Bill C-7 amends the criminal code to render medical assistance in dying more accessible to patients requesting it. CPC 1, the specific amendment, seeks to create a new offense against a person who would compel a health professional to offer the service of medical assistance in dying. This is a new concept that is not envisioned by the bill. As House of Commons Procedure and Practice 3rd edition states on page 770, an amendment to a bill that was referred to committee after second reading is out of order if it is beyond the scope and the principle of the bill. So it's in my opinion that Amendment CPC 1 is creating a new concept that is beyond the scope of the bill. Therefore, I rule this amendment to be inadmissible. This ruling also applies to CPC 10, but we'll get there shortly. I will give the floor to the legislative clerk to explain this a little bit further for members' clarity as well.
Thank you, Madam Chair. Mr. Moore. CPC 1 basically add the number 240, section 241.5 that is being described in CPC 10 that is on page 19 of the package. And as you pointed out, basically it criminalizes the activity of compelling a health professional to provide medical assistance in dying. Since the bill does not create a criminal regime, unlike C-14 that was creating a new criminal regime for all sorts of activities related to medical assistance in dying, C7 doesn't do that. So therefore, it would go against beyond the scope of what the bill does.
Thank you for that, Mr. Clerk. Mr. Moore, is that your hand raised on this specific matter?
Well, yes, it is. I think that it's very clear that this amendment deals with something that is very topical to C7. It deals with the physician and patient relationship. It's a necessary amendment in light of the testimony that we heard on C7. So I do need to challenge the chair's ruling in this regard.
Thank you for that, Mr. Moore. We'll go to Mr. Clerk to call the question to sustain the ruling.
Thank you, Madam Chair. Mr. Cooper?
I vote against the ruling.
Ms. Findlay?
I vote against the ruling.
Monsieur Thériault?
Je vote pour maintenir la décision.
Mr. Garrison?
I vote against the ruling.
Mr. Kellaway?
I vote yes.
Mr. Lewis?
I vote against the ruling.
Mr. Maloney?
I support the ruling.
Mr. Moore?
I vote against the ruling.
Mr. Sanga?
I vote in favor of the ruling.
Mr. Virani?
I vote in favor of the ruling.
And finally, Mr. Zubiri.
I vote for the ruling.
So, yeas pour, Madame la Présidente. 6, et nays contre, 5, 5.
Thank you. So the ruling is sustained. We will now carry on to our next amendment in the package, which is PV1. And because it is moved by Mr. Manley, my understanding is that all of these PV amendments are deemed moved in the committee because you're not a member, a permanent member. So, Mr. Manley, I'll turn to you. Can I turn to Mr. Manley to speak to it? So, Mr. Manley, I'll turn to you to speak to PV1 at this time, sir.
Thank you very much, Madam Chair. So this motion calls on people that experience enduring physical or psychological suffering that are seeking MAID, that is caused by that illness, disease, or disability, or that state of decline, is intolerable to them and cannot be relieved under conditions that they consider acceptable, and is not the result of deprivation, social disadvantage, lack of support, or perceived discrimination. In my discussions on MAID with the local disability community, there was concerns raised. I was sent this motion by the executive director of the Nanaimo Association for Community Living, Graham Morey, and this was a motion that came through Inclusion BC. In my community, in my office, every day I see people who are homeless go by. There's a large homeless camp behind my office, and I see people in wheelchairs and with walkers, and I know that there are disabled people in that camp, and that the health issues that they face continue to degrade their health because of their deprivation, because they are homeless. And people in my community wanted to ensure that there was more of a safety net in place for people with disabilities. I believe that this bill does protect people with disabilities, but I think that the language needs to be clear so that people feel satisfied that they're protected. Thank you.
Thank you, Mr. Manley. Mr. Virani on PV1.
Thank you very much, Madam Chair, and welcome to Mr. Manley, and thank you for the contributions you're making to the debate and by proposing amendments. This is a difficult one. I'll confess, obviously I think all of us have some sympathies for the issues that you're highlighting: deprivation, social disadvantage, lack of support, and perceived discrimination. There's no doubt about that. But I think what really is the concern that I would outline is just about the autonomy of the individuals. So I don't deny that the suffering that people experience can be exacerbated by those factors that you outlined. But what I'm concerned about is that if we were to proceed with this kind of amendment, what it effectively would do is proceed to bar access to MAID for persons who are suffering intolerably if they also happen to be suffering as a result of their discrimination or social disadvantage. And that to me would undercut their autonomy and their dignity. I think we have to address the ills that you're identifying, there's no doubt, and those stakeholders that communicated with you are highlighting very important pressing causes. But I think the way we address those ills is through societal changes and through additional supports, but not by denying people in that situation access to MAID if they are otherwise eligible, make a voluntary request, and give informed consent. So on that basis, I would be moving to not support this amendment, but I thank you for offering it up.
Thank you, Mr. Virani. I have Mr. Moore next on the list on PV1.
Thank you, Madam Chair, and thank you for this amendment. I think this is a sound amendment. It speaks to some of the testimony we heard. I know I keep referencing back to the testimony because that's important in how we do our jobs as members of Parliament and members of this committee. We had very limited testimony, but the testimony we've heard, and then the written submissions that have come in, and the 4 days of testimony that we had, we heard over and over that lack of support. Someone cannot make a true decision. These decisions aren't made in a vacuum, so their choice is not a true choice if, as referenced in our amendment, that the palliative care options aren't there, but also in this amendment, enduring physical, psychological suffering, not the result of deprivation, social disadvantage, or lack of support, or perceived discrimination. I think this is an amendment that is well thought out. Glad it was brought forward, and based on the witness testimony that we've heard, particularly around vulnerable Canadians that don't have some of the opportunities that we may have, I think this is one that is worth supporting. Thank you.
Thank you, Mr. Moore. I have Madame Finley, then Mr. Garrison, and then Mr. Cooper. So go ahead, Madame Finley.
Thank you, Madam Chair. I think this is a well thought out amendment, and I thank our colleague, Mr. Manley, for his contributions here. In reference to earlier statements that we all have some sympathies, I have a great deal of sympathy. I think listening to persons with disabilities in particular who came forward and spoke to us, but also doctors who have the care of vulnerable patients. There are socioeconomic elements here that should not be the reasons people make these choices. Lack of supports, lack of advantage should not be the reasons to implement MAID. Also, in earlier statements by my colleagues talking about autonomy and yet highlighting the competing tensions, if we truly do believe in autonomy of people to make these decisions, they should be able to make them themselves about the competing tensions or their competing rights. Which of their rights do they feel they want to emphasize? Which do they want to exercise in the options available? And there should be true options available. It's very compelling to me, the testimony we've heard on these issues. And when we talk about societal changes, the people who are in the front line of this, the healthcare professionals and the patients and future patients, are the ones dealing with this directly, not us. We're legislators. We're trying to look at it in an overall context. We all want to relieve suffering. But if we truly believe in autonomy, then that means that we, as a society, as government, as legislators, and as compassionate Canadians, should be in favor of an amendment like this, which makes it very clear that these decisions should be free of any kind of deprivation or social disadvantage. So I'm in favor of it. Thank you.
Thanks, Madame Finley. We'll go to Mr. Garrison and then Mr. Cooper. Go ahead, Mr. Garrison.
Thank you very much, Madam Chair. I know that this amendment arose from concerns in the disability community, and I have had many discussions with members of the disability community, both locally and nationally and provincially, on this amendment in particular. It is a very broad amendment, and while it arises from the disability community, it would apply to any and all marginalized communities. It is not exclusive to the disability community. And I think inadvertently what this amendment does in the broad way that it's stated is it would potentially deny autonomy to others to make decisions about the end of their life. And so while I absolutely believe we have to have further discussion of the very valid concerns of the disability community and our large failures to provide supports to that community, and I believe that those, as I've said many times, need to go on in a special committee of the House to examine those broader issues, I think this amendment inadvertently, by modifying the tests to receive medical assistance in dying, is unconstitutional and would be ruled so by the courts because of its very broad impact of members of other groups other than those with disabilities. And in the end, also, it does, I think, inadvertently deny autonomy to people with disabilities. We must endeavor to make sure that the choices they have before them are real and that they receive equality of supports to lead a good life. But in the end, I believe that this amendment would affect the autonomy both of disabled people and other marginalized people in our society to make decisions about how their life ends, not about ending their life, but about how it ends. And for that reason, I am opposed to this amendment.
Thanks, Mr. Garrison. We'll now go to Mr. Cooper. Go ahead, Mr. Cooper.
Thank you very much, Madam Chair, and I want to speak in strong support of the amendment put forward by Mr. Manley. I would note that in the preamble of Bill C-7, there is reference to the fact that Canada is a state party to the United Nations Convention on the Rights of Persons with Disabilities and recognizes its obligations under it, including the respect of the right to life. Now, I believe that this amendment is consistent with that preamble, that which the government purports the bill seeks to do, which is to, among other things, respect Canada's obligations under that convention. And in that regard, I would note that Article 10 of the applicable convention provides that, quote, state parties reaffirm that every human being has the inherent right to life and shall take all necessary measures to ensure its effective enjoyment by persons with disabilities on an equal basis with others, closed quote. Now, further to that, I would note that the UN Special Rapporteur, even before the introduction of Bill 7, raised concerns about Canada's medical assistance in dying regime. To that end, she noted in her statement issued on April 12, 2019, quote, I'm extremely concerned about the implementation of the legislation on medical assistance in dying from a disability perspective, closed quote. And she then went on to express concern about the absence of alternatives for persons with disabilities. So I believe that this amendment speaks to some of those concerns and would go a long way to guarding against vulnerable persons being induced to make a choice that doesn't fall within their autonomy because they simply feel that they have no other options because of their marginalization.
Thank you, Mr. Cooper. I have Mr. Moore, then Mr. Lewis, and then I'll call the question. Go ahead, Mr. Moore.
Well, thank you, Madam Chair. And yeah, I want to echo the points that Mr. Cooper just made. But I'd like to add, Mr. Garrison mentioned, or I guess presupposed, how a court, some future court, may look at this. And it's a reminder of how we came to be in this situation in the first place when the court decision and the Tershon decision significantly changed what was a brand new piece of legislation, which was C-14, and had been less than 5 years old, hadn't even had its first review. And in that decision, said you no longer have to be in a situation where death is reasonably foreseeable. And the government, rather than appealing the decision, has instead immediately dropped any efforts to defend its own legislation and then introduced C7. I don't think the consultation with the disability community, persons living with disabilities, has been robust enough. And the reason I say that is based on the 4 days of testimony we had. There's one particular day where there was a number of groups represented that speak for people, Canadians who are living with disabilities. As Mr. Cooper just put it, we have an obligation. We have international obligations. We have an obligation to do the right thing. And the message we heard back is people are going to be put in a position based only on them being a person living with disability that puts them at a disadvantage compared to everyone else. So I think quite the opposite. Unfortunately, this bill singles this group out, and we've been hearing that loud and clear. If members of the committee have been getting the same correspondence that I've been getting from groups from coast to coast, local groups as well as national groups representing Canadians living with disabilities that find some of these amendments to be an affront to them as Canadians that are seeking to be wholly involved with all that our country has to offer. And that's why I think we have an opportunity here. I'm just asking members of the committee to really think openly about what we heard and about what Mr. Manley has very thoughtfully put forward. I'm reading every word of his amendment, and to me, it speaks exactly to the deprivation, social disadvantage, lack or support or perceived discrimination. What this amendment is saying is that the decision to receive assisted dying cannot be the result of one of those conditions. How can we, as committee members, in good conscience, not support an amendment that responds so directly to the testimony we heard and provides an element of safety? Well, we're going to get to other amendments later that were where C-14 had protections in place for Canadians under our assisted dying regime. Some of those protections are being pulled out with C7. I think this amendment is a thoughtful way to say we're listening and we're acting cautiously, we're proceeding with caution, and we, above all, are going to take every step necessary to protect the rights and the ability of persons living with disability to be fully engaged in our society. And I know you all heard what I heard through you, Madam Chair. Sorry, I know committee members heard what I heard, that this bill is in danger of really hurting a lot of Canadians living with disability and how they see themselves as participants in Canadian society. And I think this amendment, if we could all support it, Madam Chair, would go a long way to saying that we were listening when they took the time to appear before us as witnesses.
Thank you very much for that, Mr. Moore. We'll go to Mr. Lewis and then we'll call the question. Go ahead, Mr. Lewis.
Thank you, Madam Chair. I appreciate it very much, the opportunity to speak to this. And first and foremost, I want to thank through you, I want to thank Mr. Manley for bringing this amendment forward. I think it's fantastic. I think it's perhaps doesn't go quite far enough, but at least it's a first step for some protection for those people with disability. We heard some great testimony on both sides, and I believe that we all took something away from it, but probably the most compelling, probably the one that really touched me the most was our folks that truly just threw their stories out on the table and says, here's who we are, here's where we came from, and here's the shortcomings of this bill, and we're begging, we're pleading you for help and support on this. So this amendment begins to scratch the surface of the help that they need, the respect that they deserve on so many fronts. So certainly speaking in support of this, Madam Chair, through you, it's going to sound crazy, to yourself. Question is this. So I know in our first amendments, Madam Chair, you had voted, or sorry, you had made a ruling on the amendment. And specific to this one, I hadn't heard if there was actually a ruling on this one yet. And the reason I bring that up, Madam Chair, is just for clarity for all members. I did recognize in the last round of voting on the amendment, the mover actually voted for your ruling, which was something that typically happens. So I just was wondering if we could have the amendment spoken to, your ruling comes through, and then we go forward. But if I missed something, I apologize in advance. Thank you, Madam Chair.
Thanks for that, Mr. Lewis. And no, I do not have a ruling on PV1. So having exhausted the speakers list, we'll call the vote now. Go ahead, Mr. Clerk.
Thank you, Madam Chair. Mr. Cooper?
In support of the amendment.
Ms. Finlay?
I support the amendment.
Monsieur Thériault?
Je suis contre.
Mr. Garrison?
I vote against.
Mr. Kellaway?
I vote against.
Mr. Lewis?
I vote in support.
Mr. Maloney?
I vote against.
Mr. Moore?
I support the amendment.
Mr. Sanga?
I vote against the amendment.
Mr. Virani?
I vote against the amendment.
And Mr. Zuberi?
I vote against the amendment.
Donc, yeas pour 4, 4, et nays contre 7, 7.
Thank you, Mr. Clerk. So the amendment is defeated. We will now go on to BQ2 or BQ3. Just to clarify, if both BQ2.
En fait, c'est BQ3, Madame la Présidente.
It's BQ3.
BQ3.
Thank you. I'll just pass the floor to you, Monsieur Thériault, to speak to BQ3, my understanding. And I understand that you will not be putting forward BQ2.
Exact.
Exactly. So there are two sets of safeguard measures. One set relates to natural death that is foreseeable, and there are safeguard measures when it is not foreseeable. The criteria for the foreseeability was removed from C7, but when we look at the two sets of safeguard measures, we go back to that criteria. And some witnesses, some physicians told us that it is not a medical criterion and that it is a vague criteria and that it brings a lot of confusion. So what I wanted to do was to bring some clarity so that we can get both sets of safeguards. It's not about getting made, it's about what surrounds made for an imminent death or made for a death that is not imminent. So it's about accessing the both sets of safeguards. So after foreseeable, I would add, because the person has received a prognosis of 12 months or less as to the specific length of time. So that's a very clear criteria, and It's part of medical practice, taking into account all of their medical circumstances, the medical practitioner or nurse practitioner, and so on. And the other aspect.
Régime de mesure de sauvegarde.
This is regarding the second measure when natural death is not reasonably foreseeable because the person has received a prognosis of more than 12 months as to the specific length of time that they have remaining. So what I'm adding here is a precision. I'm precising. It's being more specific so that practitioners will be able to make a prognosis. This is what doctors do every day. They make prognosis. And when we're talking about a medical assistance in dying request, we're talking about less than 12 months. But in this case, when it's a case where death is not reasonably foreseeable, it would be more than 12 months. And if things changed, this person would still be entitled to this system. So it's basically to have two measures in place, 10 days or 90 days.
Mr. Thériault, Mr. Maloney, if you'd like to speak to BQ3 that's on the floor right now.
Thank you, Madam Chair, and I'd like to thank Mr. Thériault for putting forward the amendment, and I admire the rationale for doing so. I mean, we are always seeking to provide as much precision to things as we can, but there are times when doing so overly complicates matters, and unfortunately, I think this may be one. Reasonable foreseeability is a not a new concept, and it's not a precise concept. Doctors are put in a position in dealing with MAID of having to assess timeframes, and as we all know, timeframes for end of life are never exact. So putting a doctor in a position where they have to deal with a 12-month cap is putting undue pressure on the doctor, and it's creating an artificial deadline, because if a doctor's put in a position where they have to render a decision that with that time frame in mind, it might result in changing their decision so that it's not so that it's complying with the precision requirement, but it's not a decision that's really capable of being that precise. And that's not in any way going to benefit the patient, and it's not going to benefit the medical profession either. So I think, although I appreciate the amendment, it's noble in its intent, but it's putting way too much pressure, artificial pressure on practitioners who are going to be dealing with these situations. So for that reason, I would oppose it.
Thanks, Mr. Maloney. So I have Mr. Virani, Mr. Moore, and then Monsieur Thériault, and then I'll call the question. Go ahead, Mr. Virani.
Yeah, I just want to elaborate a bit upon what Mr. Maloney was saying, that I think, you know, it's sometimes it gets complicated, it gets a bit muddled when we get so mired in these terms, but we had a regime under C14 that talked about sort of an end-of-life regime. We have a decision about reasonable foreseeability in Truchon that says that if you keep it to just an end-of-life regime, you're not actually promoting the dignity and the autonomy of individuals. Therefore, a change must be made. The change that must be made is what's presented before us now in C7, and it creates two tracks, right? So there is a track where your death is reasonably foreseeable. Then there's a track where your death is not reasonably foreseeable. And there's reduced, there's a facilitated access when the death is reasonably foreseeable. And there's enhanced safeguards where a death is more a natural death is more long-term in what we call the track 2. In trying to sort of narrow down how you divide between something that is a death that is reasonably foreseeable versus one that is not, I appreciate what Mr. Terry was trying to do, so I'll echo the sentiments of Mr. Maloney. I appreciate his statements that he's made in the House. I appreciate his interventions in this committee. I know that he and his party believe very strongly in the model that Quebec has rolled out provincially, and ensuring that there is access that grants autonomy and dignity to individuals. But where I'll differ with him is just this idea about putting a demarcation on the 12 months as a demarcation, a line in the sand, so to speak, as to when something becomes reasonably foreseeable or not, determining whether you fall into track 1 or track 2. And the reason for that is that everything that I've learned through the course of this committee study and everything that I've learned from the consultations that I was privileged to be a part of in January and February indicates that the medical practitioners that are involved in this very sensitive, very complex assessment are doing so with a lot of professionalism and with the care of the patient in mind. And I remain strong in that faith that they will continue to execute their functions professionally, and allowing them to have the flexibility to make that determination rather than carving out a line, to my mind, is the best path forward in terms of ensuring consistency with the regime in the past, but making the constitutional changes that were required by the Chouchon Court. So simply for that reason alone, that I think demarcating 12 months as a line in the sand would not be beneficial. And in some respects, I certainly wouldn't want the inadvertent consequence of limiting access to MAID for those who would otherwise be eligible, who otherwise had made an informed decision and were trying to make an autonomous decision, and impeding or limiting that autonomy. Thank you.
Thank you, Mr. Virani. Mr. Moore, you're next on my list.
Well, thank you, Madam Chair. And an individual's ability to access MAID does not hinge on this particular amendment. What this amendment, as I see it, as I understand it, is to fill the legislative vacuum that is being created with this legislation. If we asked every member of this committee and everyone participating today, what is reasonably foreseeable, what is someone whose death is reasonably foreseeable, we could get 32 different answers, because this legislation doesn't get the job done. It's not precise. It's our job to wherever we're able to provide a precise direction, especially on a piece of legislation that is literally dealing with life or death. So Bill C7 opens up Canada's assisted dying regime. Originally, under C14, someone's death had to be reasonably foreseeable. Bill C7 says, no, your death does not have to be reasonably foreseeable in order to access MAID, which means someone who is not dying, as we may think of, someone who may have 10, 15, 20, 30 years to live, is eligible to receive MAID under Bill C7. So it is incumbent upon us, I believe, to try to be a bit more precise. We've all heard doctors, we've seen scenarios where someone is given 6 months to live. Someone's been given 2 years to live. That happens all the time. These are the calls that doctors make. I don't accept that by saying 12 months is somehow making any more difficult a situation than to just throwing something up against the wall, which is what we're doing with reasonable foreseeability. No one knows what that means. So in a country of over 30 million people, with doctors in all of our provinces and territories, decisions that have to be made that are literally life and death, and we're saying we don't know what to say. Well, you guys figure it out. So we could have grave inconsistencies throughout the country when it comes to which track someone would be on assisted dying. There's different safeguards on different tracks. So it matters whether someone's death is reasonably foreseeable or not as to which track they fall into. So I think this is a reasonable amendment. I think it's enables us to do our job as legislators to have a bit more precision, quite a bit more precision in the legislation that we're dealing with. And it's for that reason that I will be supporting this amendment to define reasonably foreseeable as 12 months. I listened to the testimony as members did, Madam Chair. I've seen some of the submissions. There is no definition of what reasonable foreseeability is, and that, in my view, is not acceptable. So it's for those reasons I will be supporting this amendment. Thank you.
Thank you, Mr. Moore. Monsieur Thériault, you're next on my speakers list.
Oui.
Thank you. I truly appreciate the comments made by all of my colleagues. Mr. Maloney, Mr. Virani, the amendment is doing the contrary of what you stated. I talked with physicians. Physicians came and talked to us, and they told us that this criteria had been removed. They were very happy that the criteria had been removed because it is not precise enough. Medical assistance in dying is not what I'm talking about in this amendment. In this amendment talks about reasonably foreseeable or not reasonably foreseeable. These categories are still there, and this enables people to have access to the safeguards. But if there's a prognosis, and doctors are always making prognoses, it's easier for them. It makes life easier for them. Doctors want safeguards. If someone's But you have to understand that people want to live as long as possible. And if they have a cancer, they still want to live as long as possible and even longer than that. They want to stay as long as possible at home, and some people even decide to die in their own homes. So it would be easier in that case, because in that case, we would not be talking about 12 months. So in this case, we're talking about 12 months or less. You don't need to wait 10 extra days. You can have access to the safeguards when we say that death is reasonably foreseeable. And then you don't need the final consent, but at least the doctor will be able to justify that this is for a prognosis of 12 months or less. We're not talking about access to medical assistance in dying. This is not the case. And then things become clearer. If the natural death is not reasonably foreseeable, we're talking usually about more than 12 months. Let's talk about Madame Gladu. In the case of Madame Gladu, it was over 12 months. If you have a degenerative illness, this isn't in the bill, but for example, as I said earlier, people want to live as long as possible. They do not want to die. And if people are having suicidal ideas, they will be treated medically. And people actually want to live as long as possible until it is no longer tolerable. So when we're talking about more than 12 months, this covers all of these degenerative illnesses. And if you think about SLA, for example, a case of SLA, ALS rather.
Je pense que les médecins vont pouvoir justifier leur pronostic, vont pouvoir justifier leur pratique parce qu'il arrive, j'entends la traduction anglaise.
Hearing the English translation. So doctors with a very unclear criteria, they will use the safeguard measures without having to justify anything when they say, well, it's not foreseeable, or it's foreseeable or not. But I think that at some point we have to have some rigor, and it was requested by one of the Quebec practitioners who has Dr. No, who has a lot of experience. Go take a look at his testimony. So that is why I do not agree with you, Mr. Maloney and Mr. Wenani, and I agree with Mr. Moore that this bill at some point should give us more clarity, and this amendment does give us more clarity.
So, Madame Findlay, I have you next on my list. Go ahead, Madame.
Thank you. It seems to me that this is actually a very important amendment, and we shouldn't get wrapped up in trying to keep the bill exactly as written if these amendments being put forward actually improve it. We heard testimony from doctors. I heard it very clearly saying that this is very problematic. A general comment, reasonably foreseeable, not reasonably foreseeable. What does that mean? You know, this isn't just like any other type of medical care. We're really not talking about a therapeutic option here. That's what the doctors told us. And I'm mindful, Madam Chair, I heard our colleague, Mr. Varani, say something to the effect of perhaps the mover is married to a Quebec model. I'm from BC, so I don't exactly know what that Quebec model is, to be honest. But we heard from doctors across Canada, not just from doctors from Quebec, who were very concerned about the lack of clarity in the bill around this particular issue. I would like to think that as we sit here debating end of life, we are also in our minds thinking about the life one lives up to that moment and the right of access to meaningful care, which is interwoven in a lot of these amendments being put forward. Doctors make these decisions all the time. Just to be personal for a moment, when my brother died of cancer at 48 and we went to the doctor, they said, you have 30 to 90 days, put your affairs in order. He lived 58 days. The doctors have a very good idea, I think, when they're dealing with their patients, that what that patient is looking at in terms of time, in terms of what can be offered or not. And that is all part of those very sensitive discussions with somebody as to the intolerability of their situation or the end of life, how soon or not it may be. My take on the testimony we heard was that the doctors, the medical professionals, were saying, look, you're introducing something here that speaks to us and how we carry out our healthcare decisions, our healthcare options. But you're not giving us the parameters that would help us either. And it seems to me that it's not really just an arbitrary number. It's a number that seems to me an amount of time that seems reasonable, where it allows a revisiting and a review with that patient. It isn't speaking to the 90 days that is in the bill now. It doesn't take away from that in any way, but it does give those healthcare professionals dealing with their patients some sort of parameters, something to hold on to. I think in that respect, I thank Monsieur Theriault for bringing forward something that I think is needed and that the healthcare professionals are asking us for, and we shouldn't abandon the field in that respect. We should give them something that they can work with, something that is in itself reasonable and not unduly restrictive. And I would be supporting the amendment. Thank you.
Thanks for that reaffirmation, Madam Findlay. We'll go now to Mr. Lewis, then Mr. Garrison, and then Mr. Cooper, and then we'll call the question. Thank you. Go ahead, Mr. Lewis.
Thank you, Madam Chair. The broad prognosis of 12 months or more to replace natural death and not foreseeable, and prognosis of 12 months replaces natural death foreseeable. Predicting prognosis for cancer and non-cancer illness out at the 12-month or many months to years mark is very complicated clinically. Doctors, if they get it wrong more often than they do right due to advances in treatments, that they do not yet understand how that impacts the course of the disease. For this reason, most other countries and states have limited assisted death to prognosis of less than 6 months, including Victoria, Australia, Western Australia, Oregon, Washington, most recently New Zealand. Today, doctors are much better at prognosticating when someone is approaching their last short months of life. There is a huge body of medical evidence in the literature that speaks to the issue of prognostication. However, having some parameters around what foreseeable and not foreseeable death is would be a step forward for Canada. The courts have to date interpreted that reasonably foreseeable natural death does not need a specific time requirement, and people, even with a decade of life, have been deemed to have foreseeable death. You know, we've had the precedent setting Justice Perro ruling in Ontario Superior Court, who approved a woman with osteoarthritis based on age alone of 77 years, who May doctor estimated would have lived another 10 years. This ruling then led Dr. Wiebe to approve and provide Maid a 60-year-old woman, Robin Morrow, with Parkinson's disease, who she had declined based on prognosis of 5 to 10 years. Madam Speaker, we've had a lot of discussion. We've had a lot of great witnesses come forth. As our other colleagues have mentioned here today, it's very, very difficult to be trying to play life and death, especially within 90 days. I thank the Bloc for bringing this forward, and I will be supporting this amendment. Thank you, Madam Speaker.
Thank you. It's Madam Chair, not Speaker, but Mr. Garrison, you're up next. Go ahead, sir.
Maybe one day, Madam Speaker, Chair.
Thank you very much, Madam Chair. I appreciate the motivation behind Mr. Theriault's amendment, and I do take cognizance of the fact that he is pointing out that the 12 months is about access to which of the two tracks that are specified in the bill. However, my concern is that there is no medical dividing line at 12 months. And so I think inadvertently this does introduce an element of arbitrariness. And while it may be difficult to decide for us to decide as legislators what reasonably foreseeable means, I think that is the job of clinicians. And I think that they will do a good job of deciding that. And by putting in the 12 months, I think we risk prolonging the suffering of some people by forcing them into the second track, as I say, inadvertently. And when the goal here is to protect the autonomy of decision-making of patients about the way their lives end and to prevent unnecessary prolonging of suffering, I think we're introducing an element of risk here of doing the opposite. So I will be opposing the amendment. Thank you.
Thanks, Mr. Garrison. I have Mr. Cooper next. Go ahead, sir.
Thank you very much, Madam Chair. I'll be very brief. Let me simply say that I do support the amendment. Prior to the Truchon decision, there were inconsistencies in terms of how reasonably foreseeable was interpreted, particularly in the province of Quebec versus the rest of Canada. In the province of Quebec, reasonably foreseeable tended to be interpreted in an end-of-life context, and that in part has to do with the provincial legislation that the National Assembly had passed prior to the introduction of Bill C-14. That was not the case in other parts of Canada. So I would submit that some clarity was required, having regard for the vagueness of that term. But given the fact that Bill C-7 puts forward a two-track approach, I would submit that clarity is now essential to ensure to the greatest degree possible an even application of law in all jurisdictions of Canada. And on that basis, I support the amendment.
Thank you, Mr. Cooper. So at this time, I see Madam Finley, did you have something to add to your prior comments that is new?
Yes, I do. I'm just wondering, and through you, Madam Chair, to other members of the committee, and perhaps specifically to my colleague from the NDP, is there a length of time that you would be comfortable with? What we're seeking here, I believe, by supporting an amendment like this is some greater clarity. So I'm just wondering if you see that greater clarity as a necessity at all, and if so, would a different time frame be reasonable to you?
Sorry, just to clarify, Madam Finley, that's a question to Mr. Garrison or to the departments that are here as witnesses today?
It was actually to Mr. Garrison because through you, Madam Chair, but just trying to get some dialogue here so I can understand it. It's hard when we're just each making our little comments.
Right. Well, I will go through this. I see that there's a whole bunch of other hands that are raised now. So Mr. Garrison is one of them. So he will, in due time, answer your question, I'm sure. Mr. Virani, you're next on the list. Go ahead, sir.
Just very briefly on that point, I think the fact that it's difficult to pin down a timeline just points to the fact that these need to be evaluated on a case-by-case basis between the doctor team and the patient. It's going to be unique in every single situation. Reasonable foreseeability is done as an assessment by that medical team, a professional team that evaluates the individual circumstances of the particular individual. Trying to pin down any particular timeline, whether it's 12 months or some other time, would not be a useful exercise from my perspective. Thank you.
Thank you, Mr. Garrison.
Thank you, Madam Chair. Mr. Ronnie has essentially restated my arguments. I do believe that attempting to legislate a particular timeline between the two tracks is not the way for us to proceed. And I agree with him that, as I said in my earlier remarks, this is a decision for clinicians to make and not for us to try and set an arbitrary date which has no relationship to medical practice in the law. So practice will evolve as we go forward, and the professional associations in each province will give guidance to physicians if there are any concerns or problems which arise from the concept of reasonable foreseeability. But I do not believe that we should select any particular number of months to insert into the bill. Thank you.
Thank you, Mr. Garrison. Monsieur Thériault?
Dernier.
The last remark to try and convince Mr. Garrison. The amendment covers everything here. It's not complicated. Someone who is maybe 15 months, have a prognosis of 15 months, they're not going to be making a request for MAID. They won't do so. That doesn't exist. You won't see it. And if it is done, then the bill has decided that it would be 90 days. So nothing is changed. We're simply making clear that it would be aligned with a safeguard. So the majority of people that would be in a terminal cancer situation, they're not going to be asking for MAID 12 months ahead of time. And if they do make such a request, they can make arrangements for an anticipated request with the appropriate measures in the event that at a certain point when they would be to do would they make the request when they'd be ready to do so, well, that the doctor would not have to wait 10 days and that the doctor would not have to give another consent.
So if someone is concerned that a patient would be disadvantaged, well, it means that the amendment is not well understood. And yes, physicians need this in order to justify their practice. They do prognosis every day. Otherwise, how can one prove that death is foreseeable? Without this amendment, no prognosis is required. And someone said that it's arbitrary. Well, physicians could be arbitrary, but with this amendment, no one will be disadvantaged because in real life, no one wants to die too early. And if a patient, after having their diagnostic, becomes suicidal, well, this person will be treated because people have to be well prepared to die. And palliative care is about helping someone to die. So I don't know why you're resisting the amendment, why you think that patients will be disadvantaged. It's quite the opposite.
Ontario. We'll go on now to Mr. Moore. Go ahead, sir.
Thank you, Madam Chair. I'm just being cognizant of the time. I'm not trying to have the last word, but I think we're pretty well at the end of the time allocated for today's meeting. I'm happy to pick this up on Thursday, or I could finish asking my question.
I'd like to, get through the list, and perhaps we can vote on this before we adjourn today, just so that the debate is still fresh in our minds. It just makes sense for us to call the question before we adjourn. So I only have 3 people on the speakers list. Let's quickly get through them, call the question, and then we'll start fresh on CPC 2 on Tuesday. Is that, on Thursday, if that's amenable to everybody? Oh, I see a lot of, so Mr. Maloney, I have you next.
So actually, that doesn't it doesn't work for me, Madam Chair. I have another call to be on now. So I'm
Sorry,
sure we have
Mr. Moore, actually, there are no more hands raised, so I can call the question right now. It'll be 30 seconds, and then you can get on your call if that's
well,
okay.
Unfortunately, I still want to be able to speak to it, but I can't speak to it now that the meeting is scheduled to be over, and I'm supposed to be on another meeting. So I'd like to speak to it when we start our meeting on Thursday, if that's possible. I think it's an important amendment, and I think we're having it's important to discuss, but this meeting's scheduled to be over, and I'd still like to speak to it.
Well, Mr. Moore, we have a couple of options before us. We've had quite healthy and extensive debate on this amendment. I would like us to be able to vote on this while it's still fresh in our mind. As you said, it is a very important amendment. And so a couple of options. You can move to adjourn the meeting. We'll go to a vote or continue. Or we can hear from you and your concerns and then exhaust the speakers list and vote on this before we adjourn the meeting. I give it to the committee to decide how they'd like to handle this. Mr. Moore, you've kind of disappeared on the screen. Are you okay? While we wait to hear from Mr. Moore, then I'll continue down the speakers list. Mr. Zuberi.
Madam Chair, I think we've had a good discussion about this amendment. If Mr. Moore were here, I would be leaning towards calling the question, since we did have a good discussion on this. I'll call the question.
Point of order. Point of order.
Hey, Mr. Zuberi, you can't call the question.
My apologies.
No. Yes, Madam Finley, did I hear a point of order? You are next on the speakers list also, coincidentally, so go ahead.
First of all, that was my point of order, that I didn't think it was appropriate for my colleague to call the question. Secondly, understanding order 116 sub 2, the debate cannot be brought to an end until everyone who wants to participate is heard from. And this is a very important issue. It's a very important amendment. There was a whole list of people that wanted to speak, which suddenly disappeared when it seemed we had to end the meeting. And I really think we need to hear from everyone under that standing order. And we have a couple of hours set aside. Those hours have expired. We have a member who had to leave, and I'm sure the rest of us also have other commitments. So, we really should just pick this up on Thursday, finish the participation from the members, vote, and move forward.
Point of order, though, Madam Chair. And again, I'm reading the Green Book that's been distributed to us on a regular basis. But my understanding is the meeting, it doesn't automatically end at 1. Is that correct? I just want to clarify that. It doesn't end exactly at 1.
Madam Speaker, further to that point, my understanding is that the meeting ends when the committee members deem it to end. And if there's an absence that is an occasion by a particular party, it is up to that party to find a suitable replacement. So absent a motion to adjourn,
Madam
the meeting
Chair,
continues.
I'd move a motion to adjourn.
Sorry. So Mr. Cooper has just moved a motion to adjourn, and because it's a dilatory motion, we'll go to a vote right away. Mr. Clerk, if you can call the vote, please. Just on a technicality, Mr. Cooper's motion was on a point of order, so it is out of order. So, Mr. Cooper, if you'd like to move that motion that's not in a point of order.
Okay. To be in full compliance, I will now so move the motion.
Thank you very much. Mr. Clerk, go ahead.
I have a point of order, Madam
Sorry,
Chair.
Madam Finley, we're just voting on this dilatory motion right now. Thank you.
But it's a technical issue, Madam Chair.
What's going on?
Mr. Moore cannot get in with his video. He's trying to, and I don't want his vote not to be counted because of a technical issue. If you could just give a moment to let him get back on. He can hear the meeting, I'm told, but he can't be seen, and I believe he has to be seen to have his vote counted.
You are correct, Madam Finley. We'll just suspend for 30 seconds as we wait for Mr. Moore to rejoin us. If we can have somebody from IT connect with Mr. Moore to ensure that that he's well supported for IT purposes. Who just said my? Mr. Maloney. Yes, go ahead, Mr. Maloney.
I'm sympathetic to people who have technical difficulties, but Mr. Moore signed off on the meeting.
Oh, he's back. I see Mr. Moore is back, so go ahead, Mr. Clerk.
In support.
Ms. Finlay.
In support.
Monsieur Thériault.
Je suis pour.
Mr. Garrison.
In favor.
Mr. Kellaway.
No.
Mr. Lewis.
I support.
Mr. Maloney.
Against.
Mr. Moore. Mr. Moore, can you hear me? You're on mute.
You're on mute, sir.
Thumbs up means in favor? Yes. Mr. Sanga?
Against.
Mr. Virani?
Against.
Mr. Zuberi?
Against.
So yeas pour 6 and nays contre 5. Yes.
So the motion carries and the meeting is now adjourned. Thank you, members.